Good morning. Repetitive question, here it comes. Has anybody read any newspaper articles or watched any TV coverage or been spoken to about the merits of this case overnight? You're still on TV. Well, all right. Next witness for the defense.
Judge Jeff Weill.
If you'll come around and get one, please.
You swear affirm to tell the truth, the whole truth, and nothing but the truth, that you got? I do.
All right, direct examination.
Test 1, 2, 3.
Background. Sir, you are Judge Jeff Weill.
I am.
And are you a circuit judge of Hinds County?
That's correct.
Court?
Yes.
And what year were you first elected circuit judge?
2010, 6 long years ago.
Could you give the jury the benefit just of your professional background as a lawyer and judge before you were elected judge? What was your background?
Sure. It's been a while since I recounted it. And just a point of personal privilege, I'm hearing impaired. I can hear you if you speak at that level, but if you speak into the microphone, it's great. I heard the question.
So, Judge, you and I have something in common. We're going to shout at each other, because I can't understand.
All right.
We're going to shout at each other, okay?
All right, I'll try to talk into your right ear if you'll try to talk into my right ear. I don't know how much detail you want, but I was in private practice for a long time, from 1982 through my election to the bench in 2010. I was an assistant district attorney. I was an investigator for the district attorney's office. I've been a city councilman in the city of Jackson for a few years, and I had a law partner for a brief period of time, but for the most part just private practice and just generally limiting my practice to whoever might walk in the door.
All right. Judge Weill, based on your background both as a judge and as a prosecutor, well, first I'd like to bring Judge Will's attention to Exhibit D68, the special responsibility of the prosecutor to receive the evidence. Judge Weill, I'm going to show you a document to receive the evidence. It's Exhibit 3.8. Are you basically familiar with that, sir?
I don't believe I am. I have been a prosecutor since 83. So I'm really not familiar with that.
All right. Well, let me ask you this, Judge. As a judge, you have to deal with prosecutors and make a determination as to whether they're acting properly or improperly, don't you? As a judge, is that part of your responsibility?
That is part of my responsibility, not only prosecutors, but defense lawyers. I have obligations to make sure they're doing right, and if they violate any codes of conduct or break any laws, I have an obligation protected by judicial privilege to talk to the appropriate authorities, whether that's the state bar or law enforcement.
Yes, sir. Well, just in that connection, I don't want to go into details about any other case, but in the past, you have regularly exercised your authority over, especially public defenders, haven't you, Judge Weill?
Exercise my authority.
Yes, sir. For example, by holding them in contempt of court or by threatening them in contempt of court and things of that sort.
Your Honor, I'm Frank Trapp, as the court knows, the jury may not know. I'm a lawyer, and I represent Judge Weill personally in trying to assist in this matter. As the court knows, there's a time-honored and long-sanctified, if you will, judicial deliberative and mental process privilege and their obligations under the Code of Judicial Conduct Judge Weill has not been called here to be an expert witness in other matters, and so we're asking things about cases that go way outside the scope of my knowledge. And I have no specific objections to this particular question, but it is far afield, Your Honor, and I don't mean to interrupt the court of this process in this way, but I do feel obligation to exercise those objections in order to be certain that I am seeking to protect those privileges on behalf of Judge Weill and all of the judiciary.
Mr. Frank, do you or do you not object? This is correct. I thought we were objecting, and at first you say you don't object. I don't know.
I do object to anything beyond that question, dealing with other cases and a broad general question. Does that make it?
I take that to be
My
irrelevant.
fundamental is questions need to be targeted in order that I can make those objections as opposed to, I'll call it that.
Interpret your statement to be an objection on relevance grounds, succinct. What he may have done in the past with some public defender, succinct.
I'm on, Judge Weill, the court sustained that objection. I want to ask you about the document that's on the screen.
It's not very clear.
You can't see it very well.
Also have a vision impairment, get a go. That's better, not perfect, but better. Yeah, that's quite clear. Thank you. Sorry.
It appears that this document has been received as evidence in the case that a special responsibility of a prosecutor includes refraining from prosecuting a charge that the prosecutor knows is not supported by probable cause. See that, sir?
I see that sentence in the context of the larger document, yes, sir.
And it also provides that he has a duty to make
I'm going to object to leading. Just ask a question.
Let him finish his question, I'll rule.
I'll ask you a different way. Is it or is it not the responsibility of the prosecutor to assure that the accused has counsel?
I know that's a responsibility that I, as a judge, take seriously. I don't know, frankly, what responsibilities fall on the prosecutor.
Would you disagree with what's here in 3.8b? Would you disagree with that then?
Let me read it. I've read the question. I've read 3.8b. What's your specific question?
Do you agree with that or disagree with it, Judge Weill?
Well, it's a rule passed by the Mississippi State Supreme Court, and generally they rule on my cases, and I agree with what the Supreme Court does. So yes, I do agree with that.
Now, going down to number D, and it says, make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigate the offense, etc. You read the whole thing, but that's the...
All right, let me read. Were you finished reading?
Yes, just you read the whole thing.
Put himself or out loud.
If you would, Judge Weill, for clarification, just read all of D and make sure you're reading and understanding.
You want me to read it out loud for you?
Yes, sir, if you would.
All right. Sub D, make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigate the offense, and in connection with sentencing, disclose to the defendant and to the tribunal all unprivileged mitigating information known to the prosecutor, except when the prosecutor is relieved of this responsibility by a protective order of the tribunal, and.
My question to you is, as a sitting circuit judge in this particular, what's like that, in the Christopher, are you familiar with the Christopher Butler case? Are you familiar with the Christopher Butler case?
I am familiar with the Christopher Butler case.
Were you aware in that case that there was an allegation that there was a tape recording made of the search by Bureau of Narcotics agents of the Butler home? Were you aware that that existed?
Your Honor, I will object to that question. I think the code of judicial conduct.
Sustained.
Let me turn over to comment if I could. There's a comment for this rule.
When you say this rule,
3.8.
the one that you just referred to?
Yes, sir.
Thank you.
The comment reads, a prosecutor has a responsibility of administrative justice and not simply that of an advocate. You see that comment?
I see that comment.
What do you understand that means?
Your Honor, I object to that question.
Sustained. All right. I want to show you an exhibit, sir, that's already been received in the evidence as defense, exhibit 62. May I show him this, Your Honor? Yes, sir. And the first question, you were the judge assigned to the Christopher Butler case, were you not, Judge Weill?
I was.
And would it be fair to say you've followed that case closely? Would that be a fair statement?
Your Honor, I object to that.
Sustained. Do you recall a motion being filed in your court by the district attorney in April of 2013 asking the charge to be dismissed of the Butler case subject to the production of certain evidence? You remember that, Judge Weill?
You're asking me about something that I contemplated as the sitting judge on a pending case, and I don't believe I can legally answer your question pursuant to the judicial order.
Well, I would object to that.
You are sustained.
Sir, do you recall further efforts? I'm showing you exhibit D61 that's been admitted in evidence. Do you recall further efforts being made by District Attorney Smith to obtain that tape in 2014?
No, I would object to the cumulative documents in the record. So, in addition to the other.
Your question, do you remember this document having been filed? Was that your question?
I'll rephrase the question, sir. If necessary, if you look at exhibit D61 up on the screen, just look at it, just to refreshing your memory of the data of regulation memory. And it's a document that's been admitted as D61, and it's entitled Motion for the Immediate Possession and Access to Video Data, etc.
What's your question?
My question is, do you remember District Attorney Smith filing a motion to get a video?
It's whether or not he remembers.
Yes, sir.
I know the date on that is January 15, 2014, roughly 2 years ago. Since that time, I've had roughly 1,000 indictments assigned to my courtroom. Your question also asked what was going through my mind as a sitting judge on a pending case in my courtroom, and I don't believe I can legally answer that question pursuant to the rules. So I'll have to object to that and claim privilege.
Asking a follow-up question. Sir, when you say that you've had 1,000 cases, isn't it true, sir, that you have had your law clerk? Your law clerk is here in this courtroom now watching this proceeding, right?
Yes, she is sitting here, yes.
And she's been here watching this trial in its entirety, hasn't she, sir?
As far as I know, she's been up there quite a bit, yes.
And even though you've had 1,000 cases, since you've had your law clerk in the courtroom during this trial and during all the previous proceedings, don't you have a particular knowledge about this particular case that you wouldn't have about 1,000 other cases?
I really don't understand that question, Mr. Weill. It's complex.
Has your law clerk not told you what was going on in the courtroom?
She is not. Very carefully, she's not relayed any testimony in violation of the rules of sequestration.
Let me ask you a little different question, Judge Weill. When we refer to 2 motions that have been filed, and you've seen those motions on the screen, do you just remember in general, and I won't put the others up there, but do you remember in general that there have been a large number of motions filed, both by the defense counsel and by Mr. Smith in the Christopher Butler case? Do you just remember in general that's true?
Get to the form, Your Honor. Not remember the conflict.
Okay, thank you.
Did the filing of motions in the Christopher Butler case by District Attorney Smith intimidate you, Judge Weill?
I believe that's a good.
So saying.
Has Robert Smith done something, sir, to intimidate you with respect to the Christopher Butler case?
I believe that would call for matters of non-public information related to the knowledge of
With due respect, go ahead and Mr. Stein.
Just a moment, sir. Sir, I want to show you what has been received into evidence as Exhibits D49. And it appears to be a hearing at which Sanford Knott
Write it down.
Sanford Knott was present, in which Robert Smith was present, and in which Adam Johnson was present.
Is there a style on the case? I didn't see a style.
I believe it. It's in late grand jury subpoenas.
Oh,
Do you remember having a hearing on June 21st, 2016, in which the issue of whether Mr. Knott's subpoena to appear before a grand jury would be quashed by you? Do you remember doing that?
Get to the form, Your Honor. I think that's not a memory. If it's in the records, please.
Question is, does he remember?
Yes.
The objection's over with that particular question. Can you answer yes or no?
I remember having a hearing generally on that topic, but I don't do dates well. So I don't remember when that might have been.
All right. Do you remember, Judge Weill, and I won't put any further documents up if we can avoid it. Do you just remember in general that on the day before Robert Smith was arrested, you had a hearing on whether to suppress Mr. Knott's subpoena to a grand jury? Do you remember that being the chronology of events?
I don't have a chronology clear or otherwise. Well,
Sir, I know it's difficult to keep up with all, there's been a lot of hearings in the Christian Republic case, correct? You agree with that?
Objection form.
Overruled.
Object to leaving.
Sustained.
Sir, would you be able to look at this and determine what you did, what your ruling was with respect to the Nazi thing?
I'm not sure what your question is. Am I capable of reading a written document? I would assume yes.
Do you remember that on the day before Robert Smith was arrested, you took under advisement whether or not you quashed that subpoena?
I really don't remember. Again, I've had, I believe you said this was in midsummer. I've had almost a score of jury trials and motions, civil and criminal, since that time, in courtroom out, and I don't remember that.
I'll turn over to page 38.
It may be captured in the document.
Or page 35. See what it says on page 35?
I do.
I'm going to find Mr. Knight has met his burden to establish a subpoena motion likely related to the improper matter of the grand jury. See that? And then it says the court is going to take the matter under advisement, however. See that?
Oh, I see it. Yes, I've heard it.
And the date of this, we earlier said, was June 21st, 2016. See that?
Slide it down.
Yeah, I know. See it. Slide it down.
And isn't it true, sir, that Robert Smith was arrested the very next day, June 22nd, 2016?
Leaving.
Sustained for leaving. He's your witness.
Would you tell the court whether or not Mr. Smith was arrested the very next day, June 22nd, 2016?
I don't know.
Did you know in advance, sir, that Mr. Smith was going to be arrested?
There were all kinds of rumors around the courthouse. Hearsay, speculation, along those lines.
Did you talk with representatives of the Attorney General's office about their decision to arrest Mr. Smith?
I don't recall. I don't think I did. I had been to the AG's office as I'm obligated to do to report clear criminal conduct by attorney, and I had been there to present evidence because I had it in my possession concerning Mr. Smith's clear violation of criminal law. So I would be unsurprised that shortly afterward, however long that was, and the time periods are fuzzy, that he would have been arrested by the Attorney General.
Thank you, sir. So you went to the Attorney General's office and reported criminal conduct by Mr. Smith?
The judicial canons required that, yes, sir.
When did you do that? I'm sorry to interrupt.
Well,
I didn't mean to interrupt you. Go ahead about the canons, whatever you do.
well, it was prior to his arrest. I know that. I was unsurprised that he had been arrested. I didn't know specifically what he was arrested for. But sometime in midsummer, I had evidence that Mr. Smith was assisting a criminal defendant, a former client of his, Mr. Turner, by providing confidential information to the defense. And when I came in possession of that, the judicial rules required me to go to whatever reporting body is necessary, let's say bar, law enforcement, and that sort of thing. And that's what I did. I turned that in for violating the law. It's a crime to do that. And then subsequently, he was arrested.
How long from the time he reported up until he was arrested would you say?
Rough guess, maybe a week or so.
All right,
really surprised me because usually those things take a while. And again, I don't know if he was arrested on what I had presented or on something else. I just really don't remember.
What Attorney General or Assistant Attorney Generals did you talk to about Mr. Smith?
I really don't remember. There's a lot of folks over there. I remember Miss Whitley. I remember an investigator, Watkins, I believe.
What attorneys, I'd like to know, sir, what attorneys did you talk to
Well,
about?
Miss Whitley, I believe, is an attorney.
Okay.
And I could be wrong, and Watley maybe was an investigator. He may have been an attorney. I don't know.
Any other attorneys, sir?
Not that I recall. They were, and there's a lot of folks over there, but for the most part, just those two.
How much time would you say you spent talking to them about Mr. Smith? In all, not only that day, but any other days you may have talked about Mr. Smith prior to his being arrested?
Objection to the form, Your Honor, is now suggesting, we're talking about one meeting, now it's thrown in gratuitously and days, suggest something that's not even, no foundation for it.
Rephrase your question, please.
Got it.
I think of relevance is prior to June 22nd.
Prior to June 22nd, 2016, how many times would you say you had talked to some employee of the Attorney General's office about Mr. Smith?
That's really, really hard to say.
Yeah.
And frankly, most of my communications with the AG's office would have been through my staff, either Ms. Steiner or Ms. Degger.
Ms. Steiner, I see it here.
Yeah, she's one of my law clerks.
That works.
And further, my judicial obligations under the Canon 3C D2, I believe, require me to do that. Also provides that I'm absolutely privileged from even talking about this. So I'm going to have to assert that, given the requirement that I not talk about it by the judicial rules.
All right, so you're asserting a privilege not to say anything about your conversations with the Attorney General before June 22nd about Mr. Smith. Am I correct?
Well, I've already answered some of your questions, but you're starting to dig down deep on some detail that the law does not allow me to talk about. And I'm uncomfortable with that because I've got a lot of obligations to the rules of judicial conduct.
Sir, are you admitting or denying, let me make it a little clearer if I can. Did you or did you not have knowledge before Mr. Smith was arrested that he was going to be arrested? Did you know that or did you not know it?
Your Honor, I object to that. It's been asked and answered.
Your court, please. Counsel could claim a privilege on behalf of the client, but it's Attorney General's position to be just making general objections rather than having a, I mean, he can claim a privilege for him, but as far as just making relevant objections, that's responsibility of the Attorney General's office.
I'm going to say details about his way reported to law enforcement or judicial performance.
Sir, is it true or not true that the very day after Smith was arrested, you entered an order prohibiting Mr. Smith from going into the grand jury? Is that true, sir?
The dates are fuzzy. I don't recall.
You don't recall the date?
I don't recall the dates. I really don't.
What, if it were the date, wasn't it a detailed order, sir, that went over several pages? Do you remember that?
I'm going to object to former question as well as this.
It is legal sustained.
I would ask court to declare an adverse witness.
Allow you to cross examine?
Yes.
Not at this time. I will not do that.
Sir, if the county had just a minute to find the order, I don't know. I have a copy of my 12 county.
You're talking about the June 23rd, the administrative order?
Travel annual report commission. Certified order. Have administrative order for immediate disqualification of the Hinds County District Attorney. Can I answer that, John?
You better stay one together, I might lose some people. Is there anything on that page?
So this is
Number back. All right, I've received in my hand the document in hand.
what's that? Can you identify that document?
It's titled Administrative Order of Immediate Temporary Disqualification of Hinds County District Attorney. And it's stamped filed June 23, 2016.
What day did you sign it?
Well, let me look. I signed it on that day, June 23rd.
All right, we move to receive that document.
Again, gotcha.
That's the relevance on it, huh?
Councilman Paul, I'm gonna allow it to be marked where I do, I'm gonna sustain the objection on relevance. I think it's misleading and confusing to the jury on which to kind of sustain that admissibility.
Sir, I'm sorry, I have to proceed on. Sir, is it not true? Is it true or not true that you had an agreement with representatives of the Attorney General's office that immediately upon Mr. Smith's arrest, you would enter an order prohibiting him from going into the grave?
Your Honor, I object to the reasons that I set out earlier.
Sustain.
Sir, in all of your dealings with Robert Smith, what has Robert Smith done to intimidate you or coerce you?
Many things.
All right, tell us what they were.
I'll try to be as chronologically accurate as I can. I've got a restricted area of the courthouse, and 50 people are allowed in that area. And during a hearing we had several months ago, Mr. Smith was in it, which was rare. He rarely comes to my courtroom. In my 6 years as a trial judge, he's never tried a jury trial in my courtroom. He came to that hearing, I can't remember what the hearing was, and the cell phone went off in the courtroom as one of his administrative assistants. My bailiffs, as they want to do, snatched up the assistant's cell phone, just because they don't want it going off in the courtroom. And it was in the middle of a capital murder trial, and it was distracting, so they took the cell phone up. And Mr. Smith approached me vigorously to try to get that back. Sent people out of my office, actually banged on my chamber's door in a restricted area of the courtroom. He brought a camera crew back, and when my law clerk initially opened the door, then I came to the door, he very belligerently demanded his cell phone back. It wasn't his. She was going to get it back tomorrow anyway, but he was just essentially out of control. That night at home, I got a text message from Mr. Smith, essentially threatening me. I don't know if y'all have seen it or not, but it was a text message that said, "I'll see you at the courthouse tomorrow. You know, you may be high-handed, but I want that cell phone back." Very aggressive. It intimidated me. I was intimidated by it. He also issued 4 subpoenas for me over the last year, 2 of which were for a grand jury, and another was for hearings in this matter, making it clear that he wanted to send a message to me. And you know, I'm a judge in the busiest county of the state. I try a heck of a lot of cases, 60% or more violent criminal cases, and I got to be on my toes. And when I start getting threatening, angry, belligerent action by a prosecutor, I worry about it. And so those are the ones that jump to mind, Mr. Lee.
All right, you mentioned, is that his cell phone, one of his assistants?
And his cell phone, one of his assistants, but I'm glad you brought that up, because there was another court hearing where Mr. Smith whipped out his cell phone in the middle of an argument and started calling somebody, checking his email or whatever, and we retrieved that. But just briefly, we returned it that day.
All right, so when I asked you the question, what all has he done to intimidate you, you mentioned 3 things you were ready to come on. He acted belligerently in trying to get his assistant's cell phone back. He acted belligerently with respect to another cell phone. And he had 4 subpoenas issued for you.
Yeah, that's right. And
is that all that he's done to intimidate you to your knowledge?
that's all I can recall. That's all that I can specifically recall. I believe there were more. I think others I'll volunteer.
So just make certain, other than the things that you have just told us about, you do not claim or allege that Mr. Smith has intimidated you or coerced you in any way except those things you just mentioned. Am I correct?
I often can't recall. And believe me, this.
All right,
Excuse me. And the reason I can't recall is that I deal with a lot of dangerous, unstable people, and just walking to my car on a daily basis is a challenge for me. So, and I get some stares and some glares, and I haven't been physically attacked, but I'm nervous about it, and so I can't remember all those specifics. I can't remember the specifics of Mr. Smith.
Sir, regarding those subpoenas and suppressing those subpoenas, who represented you in getting those subpoenas suppressed?
I believe my excellent lawyer, Mr. Frank Kraft, did it.
So wasn't it the Attorney General's office?
I don't recall. I know that Mr. Kraft was involved in some of the subpoena issues. The AG's office, by law, made it file something on my behalf. I don't remember. They've represented me on some things in the past as part of my law. They've represented Mr. Smith. I think they currently represent Mr. Smith on some things. I could be wrong on that, but statutorily, that's what they're required to do.
All right. Sir, I asked you about you being intimidated by Mr. Smith. You have dealt with Assistant Attorney Generals Patrick Beasley and Sean Buchanan, and not.
No objection. Not leading on the question.
All right.
Rephrase your question.
Do you know Assistant Attorney Generals Patrick Beasley and Sean Buchanan?
Fairly. I know who they are, and they haven't practiced in front of me much, but I do know generally who they are.
Have you seen Mr. Smith ever intimidate them?
Have I seen him intimidate them? Well, the circumstances for that, no, the circumstances for that would be unusual, because I don't think they've all been in the courtroom at the same time. But I could be wrong on that. The limited times that I may have seen them all together, I didn't notice any intimidation.
All right, sir, I want to show you Exhibit D49 again. It looks like a hearing in shows the person present, Ivan Johnson. You know Mr.
When was that, Mr. Webb? You had a date at the top.
Yes, right.
Maybe it's not. Is there a date on it?
This is June 21st, 2016, the date before Mr. Smith was arrested. Do you remember, is Mr. Johnson an attorney that was assigned to your court?
You said Spencer Johnson?
No, Ivan Johnson.
Ivan Johnson. He has been in the past, yes.
At the time that Mr. Johnson was assigned to your court, you had no knowledge that he was obtaining bribes or anything from criminal offenses, did you?
I'm not sure what your question is. If I subsequently found out information or...
No, sir. I'm talking about when he was representing you, when Mr. Johnson was appearing in your court, you did not know that he was receiving any bribes from any criminal offenses, did you, sir?
No, I did not.
Did you notice any strange requests Mr. Johnson might make regarding reduction of bonds for criminal offenses?
Objective form.
Form was wrong with the form.
He asked him, did he know of any strange circumstance? I don't know what strange circumstance is. It could be a straightforward question. In a factual matter, strange requires to be characterized somewhere.
Based on the form, I'll agree with you.
No, still objective relevance.
Sustained.
Sir, do you remember this hearing which was formed to a D49 regarding suppressing the not subpoena as being a hearing that you ordered to be sealed and held confidential? Do you remember that?
You turned away a little bit of the way that did your first question, running here again.
Without looking at this transcript, do you remember that the not matter was one of the matters that you ordered to be sealed, and you also ordered people to leave the courtroom and this hearing was not held in public? Do you remember that?
I remember over the course of the summer, there were a couple of matters that were sealed because they concerned grand jury matters, and I don't recall whether that was one of those that was sealed. It may or may not have been. I don't remember. I do remember that there were a couple that were sealed because by law, grand jury matters were not allowed to be made public, so that would have been why it would have been sealed. I just don't remember if that hearing itself was open or not.
Well, let's look here, sir. Let's look on the first page. Can you see that?
All right.
Don't you start out by telling that this is, we need to address the confidentiality of the proceedings, and you went ahead and people that were not directly concerned were required to leave the courtroom. Remember that?
Well, I haven't read what you're showing me yet. Show me where,
I'm already here, sir.
I may have said that.
Before we start, it says started, I think it's the top right there, but it says before we started with the hearing, we need to address the confidentiality of these proceedings. Pursuant to law, Mississippi law and the applicable rules of court, public disclosure of matters when the province of grand jury is prohibited. And you quoted some cases. Do you remember doing that when you started here?
I don't independently, but the document speaks for itself, Mr. Wade.
So apparently you did based on what the document said.
Well, when you say I did, I apparently said that, what you just read, but I don't see where it says I sealed the hearing. It may be in the next page. I don't know. I haven't seen the document.
All right, sir. On the next page, the court finds it consistent with this strict prohibition, that this prohibition would apply to court hearings, etc. Court finds it shall be sealed. Did you see that?
I do see that now.
All right, sir. So it appears from the document that you sealed that hearing.
I believe the document says that, yes, sir.
But it also appears that Mr. Ivan Johnson was allowed to be present.
Well, he was representing the state, I assume, and as was Robert Smith, and there may be another name at the top that I can't quite see. Same not was also a party. And when a matter is sealed because it concerns confidential matters, you allow the attorneys and some of the litigants to participate. And that's why I assume, and this is a long time ago, but I assume that's why Ivan Johnson was there also, because he was an assistant district attorney.
All right, sir. Do you remember Mr. Alexander being there? And Mr. Alexander and the other attorneys being excused from the hearing?
Being what from the hearing?
There was a Mr. Alexander there. Am I correct in saying there was a Mr. Alexander there?
I really don't recall. I know that they had a listing of attorneys that were there, and I don't believe his name was on that list. So I don't know if Mr. Alexander was here or not.
All right. Sir, do you know what prosecutorial discretion is?
I don't have the definition memorized, but I have a general idea.
Could you explain that to the jury, please?
Well, I would object to this as relevance and cause for information that's clearly out of side of scope. What he just said earlier yesterday is be part of it.
I'm going to sustain it on the relevance grounds, Counsel. We're going down the rabbit trail, and I sustain it.
Sir, are you familiar with the term non pros?
Yes, I am. It's a fancy Latin phrase for something that I think is not prosecuted.
And it's what's called a dismissal without prejudice. Is that a fair statement of it? A dismissal without prejudice?
Without having Black's Law Dictionary in front of me, I wouldn't know if non-pros was without prejudice or with prejudice.
But you don't know whether, once the case is non pros, you don't know whether it can be brought back up again. You don't know the answer to that question.
I'm not certain of the answer to that question. If you want me to shoot from the hip, I can.
All right. No, sir, I don't ask you to do that. You have how many, you answered this already, how many total years of experience do you have as a prosecutor and judge added both together?
Prosecutor and the judge?
Yes, how many years total experience prosecutor and judge?
I was a prosecutor for a couple of years, and I've been a judge genuinely the first 6 years, so do the math, it sounds like 8 to me.
Other than yourself, I'm not talking about yourself. Are you aware, in the time you have been a judge and a prosecutor, of any circuit judge requiring a prosecutor to present written evidence before he would allow a prosecutor to non-prosecute a case?
Your Honor, I object to the form of that, I object to the opinion and knowledge and it's outside the scope and your relevance.
Sustain it.
Have you ever, Judge Weill, since you have been a circuit judge, required permit, on numerous occasions, some representative of this Mississippi Attorney General has appeared in your court?
Yeah, the AG's office has a docket, a part of my docket, most of it is with the district attorney's docket.
Regarding the part of your docket that's made up of Attorney General's cases, have they from time to time asked you to non-prosecute cases? Is that how?
Yes, Your Honor. It's just clearly outside the scope of what he said he was going into, relevant, and I believe it's invasive. What's happening in other cases in the minute.
I'm going to sustain it on the relevance grounds, Counsel.
God, report, please. Just a minute. Your Honor, especially with regard to that last question, I didn't make a record. I understand outside the presence of the jury,
Ladies and gentlemen, if I could get you to follow the bailiff for just a moment to the jury, let me hear a matter of your action. All right, Mr. Jury,
So my question was, the jury's out, since the Attorney General and their attorneys have been appearing in your court, have they from time to time requested to nullify cases? Have they done that?
And this is possible. I assume they probably have, and let me explain that. In a criminal case, often there'll be multi-count indictments and or multiple indictments, and they're all disposed of during the course of the plea, sometimes a trial, and so forth. And as part of that process, as part of the plea bargaining offer, the prosecutor will agree to make a recommendation, and part of that recommendation is often now-processing or dismissing or remanding. I'm thankful for the new Mississippi Rules of Criminal Procedure because they give us some guidance on that. And I've always been fuzzy on what constitutes a remand, now-process, dismissal, and every other circuit judge I know in the state is similarly flummoxed. Putting it on the inactive docket is another option that we can have. I know I'm rambling a bit, and I'll try to get to the point. So I would assume during some of the many cases I've had at the AG's office that I have entered null process on request in that regard. Some of which I may have required a written motion as far as the AG's office. I don't recall. I fairly frequently, I'd say, especially lately, given the avalanche null process that have been coming from this district attorney's office, have requested written motions explaining why they want cases dismissed. And I think that relevant to the statute, which requires the circuit judge to make an inquiry, I think that's what I'm called upon to do.
So my question was, have you ever required the production of evidence, such as documents, physical evidence, of the Attorney General's office? Not whether you required a written motion, but you required evidence.
Well, Your Honor, you didn't ask that question. In fact, why you didn't answer the question. If you've got a question like that, you can ask it. The question was, have you ever nullified a case the Attorney General was on? And now he goes into some other topic as this.
what's your objection, Mr. Trapp?
My objection is to form the assumption of his question that they've even talked about whether he required evidence.
In the interest of saving time, Mr. Wade, where are we heading with this line of questioning? I know the jury's out. If he's not across 500 cases that the AG would prosecute, how does that have anything to do with whether or not your client is guilty or not guilty of conspiracy in aiding and assisting Chris Mullins?
Your Honor, if I understand correctly, the evidence in the case, and one of the things I anticipate the Attorney General will rely upon is the fact that Judge Weill entered an order in which he demanded certain physical evidence be presented as a condition that he's considering a null clause. The Attorney General has pointed out he denied his failure to produce that evidence. And I think it mitigates the effect, of his doing that.
How does that relate to your client's innocence or guilt on the charges we're trying before this jury?
It tends to negate the guilty state of mind, and when Mr. Smith was ordered to do that he could have perceived that he was asked to do something within the prosecutorial discretion of the prosecutor.
The essence of this whole discussion is a statute that says no prosecutor shall null prosecute a case without leave or permission of the court. That's where we're headed. And I think where we're headed is, does the judge have a right to determine whether or not that is a good faith request to dismiss? Is that where we're headed? Or does the judge just a rubber stamp for the DA? He has to grant every DA request for null prosecute. Well, I don't care if it's the DA's wife that's under indictment. If the DA presents a motion to dismiss, the judge is just supposed to rubber stamp it. That's where we are in this case. And my question is, how is that relevant to the issues of guilt or innocence in this case? Or are we going down a rabbit trail?
Well, you're honest, Judge, so my only response to that is the court, the Attorney General believes it's relevant that Robert did not comply with that order. And I simply want to point out the unusual nature of that order, and it might be a mitigating circumstance for the jury to consider in considering whether Robert had some criminal intent in not complying with that order.
next question, I'm just trying to announce my concerns from the bench.
That was all I had, outside the presence of the jury.
All right,
I
just
don't think he's ever answered the question.
ask it one more time.
Do you recall any occasion when you required the Mississippi Attorney General to produce any documents to support a motion for no clause?
And you made an objection to that.
Yes, Your Honor.
All right, I'm going to sustain it on reference. Even the jury's out, I'm going to sustain it. Wasting time.
May I ask one question? I want to ask more questions, and one might want to further that.
All right, talk to your client.
Now, we don't have any more questions.
All right, you ready? Well, maybe it's a good time for a break.
Great, Your Honor.
Well, the
That's
next,
all
all
over 60, assume on the qualified for higher penalty.
right, let's take a short 10-minute break and come back to the jury.